Welcome to the Iowa Court of Appeals. For this 10:30 a.m. session, we have two cases to hear. The first of those is Genesis Equities versus Duffield. It's number 24-1105. We have Angela Campbell for the appellant Duffield, and we have Philip Burian for Genesis. So, Ms. Campbell, whenever you're ready.
Counsel. Angela Campbell for the appellants and defendants in this case. This case, in a way, is very simple. It boils down to two contracts, and it's important to recognize that they are two contracts because the district court does conflate the provisions of them at various times during its ruling. The contract that started it was this lease, a lease with Luxair, which was later assigned to Genesis Equities. And the entire case is kind of based on this premise that the district court found, stating that Ms. Duffield, or the volley frog defendants, had breached that lease by, quote, becoming insolvent. We submit that that's legal error based on the language of the contract and the law that has been applied in this particular case, because there was no transfer of any sort of right to any sort of third-party entity as required by Section 18C of that lease. And so if you find that that is error, then it moves on to the district court's finding that Genesis Equities was in breach of the contract because they failed to provide sewer as required by the contract. Now, there is a way that you actually get to the same result based on fraudulent inducement, and that is Genesis Equities or its principals, who are the same principals as Luxair, who are the same principals as the abode entity. Jeff Witter promised and put in writing that they were going to provide an immediate option to purchase this property, and that immediate option had this convoluted way that it could be calculated, but it was based on the premise that they would have entitlements to that property, including sewer and water, right away as they were going forward, so that they could market this to purchase it for financing.
We're looking at the timing, the who breached first question, and the provision of the sewer facilities. Do we look at, is April 1st, 2019 the date for that versus the finding of insolvency of your client?
That's how the district court found it, yes. But there was never any indication throughout 2018 that sewer was actually there was ever a plan for the sewer. And so that's why we brought that counterclaim for fraudulent inducement and the breach of good faith dealing, because there was never any indication that they were actually going to put in sewer. Yes, the contract reads as by, I believe it's May of 2019, that they were going to have the sewer in. And by the time the sewer is not in, Ms. Duffield and Volley Frog are not in breach of that lease because they've made all their payments to the Genesis entities. That's why I say it's important to focus on these two contracts. They are not in breach of that lease for any sort of failure to pay under the lease. They'd made the upfront payment for the lease for the $18,000, and they complied with the provisions of that lease. They hadn't transferred anything to any other creditors. They hadn't done any of these things that they're later accused of doing. And so the district court found, though, that they were in breach of this insolvency provision, which, the way it's written, marries insolvency with a fraudulent transfer, and there was never any evidence of any sort of fraudulent transfer.
Object to, and maybe that's just what you were saying, but do you object to the district court's definition of insolvency in the ruling?
Yes.
And how the contract itself doesn't define it, so what should the district court have done?
Well, you don't even really need to pull into the law. You can just read the lease. I mean, the lease says, lessee becoming insolvent, making a transfer in fraud of creditors or an assignment for the benefit of creditors, and the assignment is not dismissed within 30 days. There's no evidence that that ever happened.
Oh, I'm sorry. Can you read that C as being or? Or are you reading it as all, like it has to happen under 18C? becoming insolvent, making a transfer, or an assignment?
No, I don't think you can read it that way. It doesn't say or. It says and the assignment is not dismissed.
I think I have the same question, but maybe a little bit different. Why would the commas set off there not be just additional things that can go wrong rather than offering the definition? Because I think I have the same instinct the district court did, which is, here's a term, it's not defined, I got to figure out what it means from somewhere. And it seems like Judge Greer suggested that's a list of stuff rather than a definition. So help me understand where you're coming from.
Sure, and even if you separate them, she still doesn't become insolvent during, I mean, if you just divorce it from the rest of it, which doesn't make sense, why would you put it then in there together?
Contracts weird ways, right? I mean, that's probably not how I would have phrased it. I'm just trying to figure out how I can say that that is the only way to construe that term.
If you're looking at two different ways that it could be construed, it's construed against the drafter. There's no question that it was drafted by Genesis or Luxair at the time, then Genesis. But it also, she doesn't, if you divorce it completely, yes, you have a problem with the definition. Becoming insolvent, it's not just lessee is insolvent or she has to become insolvent. She doesn't become insolvent by any means other than the actions of Genesis. I mean, she has the $250,000 that she tells them she has, and she gives it to them and their property. All of that money goes to them. And so no matter what definition of insolvency you use, she doesn't become insolvent during that time unless you're counting that she owes Genesis $1 million that they're claiming she owes them based on the lease breach.
So under your reading of that provision, what facts would trigger becoming insolvent?
Finding of insolvency by an entity of some sort, a filing of bankruptcy, a transfer of your assets to some other third party, which is how I read it. You're transferring your assets away to make yourself insolvent. We don't have any of that. The only transfers of assets is paying the other side for the lease and the contract.
Can I ask maybe a higher level question as I'm sort of looking at the ruling in its entirety? There are lots of adverse, I guess I would call them factor credibility findings. Which of your claims is easiest for us to evaluate without having to look past or sort of flip around some of the adverse credibility findings that were related to your client or her testimony?
And there's credibility findings, I think, for all the witnesses. You can look at it should be us looking at the four corners of these contracts. There is no indication that they're saying she's insolvent, therefore they're terminating the lease and saying she's in breach because she's insolvent. If she has become insolvent under their definition, she's insolvent from the beginning. And they continue to let her stay there. They continue to engage all this and let her run up, what they say was millions of dollars worth of past due rent. You can look at the lease and see if she didn't breach that, she hasn't breached any of it. And so that means you can look directly at the lease and see there is no question they did not put in sewer. There might be a question as whether they were standing ready or not, but there's no question they didn't do it. And that's the first violation of the breach of the lease. Now, we think this whole contract is just void from the outset based on some other aspects of it. You can look at Lloyd Ogle's opinion to determine that none of these contracts should have ever been enforced based on the terms of them. They're impossible to comply with. She couldn't have exercised that option to purchase. It wasn't clear. You have to go outside the four corners of the contract, like he testified, and I think you could rely on him. There's no challenge, I don't think, to Mr. Ogle's credibility. Once you get rid of this idea that she's the first breach of the lease, everything else gets reversed, because if they breach the lease first, they've now caused the damage from the other breach of the other contract. When you start talking about credibility, that really goes to that abode contract. I think the lease itself on its four corners, you don't even have to listen to anybody. It's clear they didn't put in sewer. It's clear that she didn't breach the lease. She wasn't ever told that she was in breach of the lease. She made her payment as required. Now, also, the judge then, instead of throwing out the lease, recognizes there's a huge problem in this lease, but instead amends it and says, well, she actually owes not the $85,000, but the $18,000, because it would be unconscionable as written, as interpreted by Genesis. But she should have been paying $18,000. Well, she never had that option. We would be in a different, she'd have been in a totally different boat if she would be saying she owed $18,000 to lease rather than $85,000. And if that value had been different for the purchase of the option based on the lack of any entitlements.
Notice to, the previous, before the assignment, in this lease, give notice to cure, 20 days to cure default for the sewer?
She complained about the sewer as early as April of 2018, or I'm sorry, May of 2018. She said there'd been a delay in the sewer, but there is no official service at that point, no. Thank you.
Thank you, Counsel. Mr. Burian?
May it please the court, counsel. Good morning. My name is Phil Burian. I'm here for Genesis Equities and the rest of the third-party defendants in the case. First of all, on this notion that the definition or the term of default being insolvency or those other things are separated by a comma, there's no reasonable reading of that clause to provide anything other than that those are three separate alternatives that are distinguished by that are called out by the word or in the last clause of that section.
Ms. Campbell's argument that if they are ambiguous, it should be construed against the drafter.
Well, that's an interesting, I mean, that's a true proposition of law. However, this document was provided to Ms. Duffield's attorney with the expectation that he would edit it or provide a counter. And there was no counter whatsoever, and there was no pushback on the amount of the price. In fact, the attorney she went to specifically told her, you don't have the capital to do this long-term. You're going to run out of money. And of course, she
was insolvent from the get-go.
She was not insolvent from the get-go. At the time she encountered my clients, she represented that she had $250,000. At the time she was paying her bills, she wasn't in debt, those debts that were being asked for her to pay. Notably, $79,000 of that $250,000 that she told my clients she would spend on the project is unaccounted for because she had another side business, this Precision One volleyball, that she was diverting funds to try and keep open this separate business operation that she had going. And in fact, the court found that had she not focused so much on this other non-contractual entity, she might have been able to make a go of this. Moreover, she told my clients that she knew how to build cheap from the Tower Terrace project, which was a similar effort to this one that failed. She expected, quote, good guy discounts. She was counting on her reputation and people's willingness to do business with her to make this deal happen. She was able to obtain financing for Precision One volleyball on this entity that was outside of this case. She was expecting money from this lawsuit with the Mangold case, which was the Tower Terrace project. And then she had a very specific plan for obtaining the rest of the financing through bank loans, sponsorships, and investors. One point that I do want to correct is that while it's not necessary for the courts to uphold the court's ruling, she did in fact make a fraudulent transfer. Footnotes 14 and 37 of the district court's opinion specifically call out some of those funds that she was diverting from Volley Frog, Iowa to Precision One volleyball. So if we were going to quibble about whether the statutory definition of insolvency applies, it still applies here. Nonetheless, even under a ordinary usage, because undefined terms are given their ordinary meaning, if you look at the Webster's Dictionary definition of insolvency, it pretty much tracks what the statutory Uniform Fraudulent Transfer Act definition is, which is not paying debts as they come due.
I wonder if you could address the question I posed to your opponent, which is about the credibility and fact findings in this case. Do those really constrain our review, or do you share your opponent's view that most of the claims, at least, are Four Corners claims, and we're talking law, and the credibility findings can sort of be put on the back burner.
Credibility findings at the district court are quite important to this case. Most importantly, Ms. Duffield, in our brief at page 26, we enumerate 17 different times in which she induced Jeff Witter to keep working on the dirt, but with promises of these investors are coming. I had a great meeting with the bank. Those were all not true. In fact, and she also argues that Genesis Equities somehow defrauded her into entering this contract. The district court found that this was actually a plum deal, and Genesis Equities and Abode Construction bent over backwards trying to help her make this deal succeed. And then when their patience ran out, only then does she turn around and start arguing about the sewer and the other frivolous claims about the construction defects. So I do believe that the credibility findings of the court are inherent through all of the findings, through all the legal conclusions. She clearly was insolvent into the fall of 2018. I don't think we need to enumerate all the house of cards that was falling on her. It's clear by the end of 2018, the creditors were circling in. This issue of whether or not the insolvency was a breach of the lease can be upheld on three different reasons. First of all, the district court found it was excused because she was insolvent. Second, the district court found that the term was not a material breach. The fact is, despite all of the rhetorical flourish, she operated this facility for 3 years, exactly as it was intended to be operated. The purpose of the lease was to operate an outdoor volleyball facility with a potential for future indoor facilities. That was the purpose of the lease in the Four Corners. That's exactly what she did without having a formal sewer system involved here. And
Agreed, didn't they, that the increase in rent from the first year to the subsequent years, the $18,000 to $85,000, was linked to the provision of the utilities by Genesis and the other companies?
yes, it was, Your Honor, and that also is the issue why the purchase price of $900 and some thousand was very reasonable, because that came with the expectation that the landlords would provide all of the entitlements to include the sewer that we're talking about here today.
So the lack of providing that could be considered a breach then?
No, Your Honor, because, again, it was not a material breach, as I was just saying. She was able to continue operating under the purpose of the lease, which was these outdoor volleyball facilities. And then, finally, there was no notice. None of this came up at all until Genesis Equities said, we're tired of you stealing our land. You need to start paying us something to get this going. And then, of course, to the credibility findings, Your Honor, Genesis Equities gave her another season, the 2020 season. They did that in an effort to give her time to get financing in order and allow her to continue on building this project. Well, we learned from one of her other former attorneys that, again, she blamed for getting her into this deal, that wasn't her purpose at all. She induced Genesis Equities into that 2020 addendum for the express purpose of trying to find a new appraiser and then renegotiate the deal that she was already locked into. In terms of breaching the Abode contract, there's little question that she wasn't paying for what she was getting. So I don't know that we need to address it that much. But again, the issue of who breached first on this April 1, 2019 sewer obligation, it was excused because she was insolvent. It was not material because it didn't affect her ability whatsoever to operate the facility. Moreover, there's no evidence that it affected her ability to obtain financing. She's the only person who believed that this lack of sewer service was somehow impeding her ability to obtain financing. The bottom line is that she's so well known in the community at this point that nobody wants to do business with her. And all the banks she had no collateral. She didn't have a business plan that was attractive. And she was trying to build a special use facility. Nobody wants collateral of an outdoor volleyball court system because they can't repurpose it for some other purpose. So that's why she couldn't get the financing. And there was no evidence whatsoever, no bankers, no brokers, no one contradicted Genesis Equities witnesses who said, you don't need to have the sewer in place. The mere right to have that sewer in place is enough to obtain financing all the time. And if that wasn't true, you could never get a construction loan for a new house. Banks loan on design plans all the time. And then finally, again, the notice issue. This never came up until she was scrambling, trying to find a way to position herself for this lawsuit. Thank you.
Reply?
I think counsel's taking a liberty with the facts. There is all sorts of discussions about the entitlements, the plotting, the breaches, as Ms. Duffield saw, in the text messages. That's Exhibit 209. As early as May 8th of 2018, Ms. Duffield is saying to Hannah Custis, in response to, is there concerns with billing? It must be communicated to me right away. And she says, delay in sewer, drainage tiling, and subs. So really early on, she's mentioning you have a delay in the sewer because she's been told they're putting the sewer in, and it was never true. They had no plan to put that sewer in, which I think is clear from this record. In addition, then we have again in August of 2018, this is long before we have any discussions about litigation, that she says the 3 engineering plots do not match what is on site. The original did not include the plot being over the North Ponds. I need to get this figured out for investors and banks. Concerns on land value, et cetera, game plan, timeline for club, an indoor facility so I can get funding and market the things correctly. She is very early on telling them, I need this stuff in place because, of course, if you're going to base your option to purchase on a value that's based on having land with entitlements, you have to have the entitlements. She can't get funding without some sort of plan for the entitlements. And she doesn't learn until litigation that there was absolutely no plan, that it was half a mile away, according to the city, when she contacted them, and that's all in the record. There was no sewer that was coming to that lot anytime soon. There was no discussion, you can search the text messages, of putting in septic. There was none of that at all. It was just simply they never planned on doing it. And that is material, because it was clearly material. She would never have agreed to invest all of her money on a plot of land she didn't own without a real option to purchase. And it's not a real option to purchase if that value is based on entitlements that are not there. The entitlements are never there. That means the value is never there, which it doesn't take, no one could get financing for that land without that. Their own expert, Mr. Drown, is the best evidence for that. He says that value is based on entitlements. And because there were no entitlements, not only the lease increase value was based on entitlements, but the value of the plot of land was based on those entitlements. Mr. Drown also is the one that during trial, for the first time, someone from plaintiffs agree that that $85,000 rent price had to be linked to those entitlements. The lease doesn't say that. The lease doesn't say it only goes up as soon as you get entitlements. It lays out all these deadlines and timelines, and that was a material part of that lease because that option to purchase was linked to those entitlements. And so because the option to purchase was clearly material, I don't think there's any discussion to the contrary, obviously the entitlements are all material.
Fact question. I think your opponent suggested an off-ramp for the insolvency question might be that there are fact findings about fraudulent transfers or conveyances. Do you agree with that description of the record?
I agree that there's a footnote talking about there was no discussion about the money and where they went. There is nothing in that lease that requires her to spend $250,000 on the project. What she said was, I have this money come in, it's going to be about $250,000. Obviously, she has expenses because this project goes on for 3 years that are not just directly related to the construction. She's running a volleyball club. That volleyball club was supposed to be housed on this land now. And so it starts to get convoluted on a damages analysis. But no, it's not, because she's paying to rent land for her club that she has, that's not a fraudulent transfer. If they have no other further questions, we would just ask that we think on this record you can reverse and have a finding that there was a breach by Genesis. And because there's a breach by Genesis, they caused then the damage from the abode contract. Thank you.
Thank you to both counsel for your helpful arguments today and your really sound briefing. We really appreciate that. Our panel will have a written decision forthcoming as soon as possible, and we will consider Genesis versus Duffield fully submitted. Thank you.